If you had said, on the contrary, that every political party will only take money through banking channels and cash receipts are prohibited, they are a corrupt practice, or that the party shall be deregistered if it starts taking money, or the candidate will be disqualified if he takes money by cash, then yes, you could have done something to stop this menace of cash, etc. This has not stopped the menace of cash. Today, my lord, candidates are still spending many times the amount by way of cash, and they are not being caught. This has to be treated as confidential by the State Bank, this information about who has purchased the bonds, and it can be disclosed only to a law enforcement agency which is pursuing some investigation. But I am saying, my lord, that if at all anybody, at one point the government had said, and this court by one interim order has also recorded, that there is at least some transparency in this because the company which purchases it has to disclose, because the political party which receives it has to disclose not the identity but has to disclose how much bonds they have to disclose, how much they have purchased, the company has to disclose, the party has to disclose how much they have received total. They say you can do some mix and match and find out who has donated. Now, mix and match can't be done by ordinary citizens for several reasons. Ordinary citizens.
Who said that you can do mix and match?
The court, in one order, has recorded this. This is on the basis of the submission of the government. On the basis of the government submission, the court, in one interim order, has recorded this. I'll show. Now, mix and match can't be done by ordinary citizens. In fact, my lord, even if I wanted to find out which companies have purchased electoral bonds, there are 23 lakh registered companies in India, 23 lakh. I would have to scan of course, every company is obliged to file the returns of their income and expenditure in the Ministry of Corporate Affairs website. And by paying some fee, I as a citizen can also access that website of that company to see what is the income and expenditure of that company. So theoretically it is possible for me to find out which company has purchased electoral bonds worth how much, purchased and given. But I won't know who have they given it to. All that I will know is total amount purchased by them. Now, citizen can't be expected to go through. Of course, we have found out about some companies which I'll be coming to. I'll give those examples, which have purchased electoral bonds because that can be seen from their disclosure to the corporate affairs. But I can't be expected to find out from 23 lakh registered companies who has purchased how much electoral bonds. But government can. State Bank of India knows. And because State Bank is owned by the government, therefore, theoretically, my lord, they can, if they exert sufficient pressure on the State Bank, they can find out who has purchased this particular electoral bond. Because State Bank has that information, though they are prohibited by law from disclosing it to anybody by the scheme. But they have that information. And they also have the information as to which political party has encashed which electoral bond. So State Bank is the only authority which can do that mix and match. Which can do that mix and match. Citizens can't do it. And I am saying, my lord, that this defeats the citizens' right to know about who is funding these political parties. In fact, my lord, in a recent judgment, the Central Information Commission has ruled that these 6 national parties are public authorities under the Right to Information Act. Now, unfortunately, despite that judgment, most of these political parties are not obeying that. They are not appointing information officers, which they are obliged under the RTI Act, so that people can ask them questions. We have in fact filed a petition in this court on the basis of that CIC judgment as well as the RTI Act as well as the fundamental right of people to know, etc., which is pending, which has been separated. by this court. But I am pointing out that here you have completely made mincemeat of people's right to be informed about funding of political parties by introducing an instrument which today forms the bulk of donations to political parties. They are the bulk of donations to political parties today, this instrument. Then, my lord, 12 of the scheme says the bond can be encashed only by an eligible political party by depositing the same in their designated bank account. So these are the broad salient features of the scheme. That, however, these are bearer bonds, and as I said, my lord, even the person who has purchased it may just hand it over to another XYZ, and that XYZ may give it to the political party, and therefore the political party can also turn around and say, I don't know who gave me this electoral bond, somebody came and gave it to me, I don't know. In fact, I have been the recipient myself of, there was this register of the CBI director. Somebody came to my residence at night and gave me 2 volumes of the residence register, original register of that CBI director. And actually, I didn't know who is that person. There were these 2 people who came and gave it to me. But when I looked at the register, I could make out that this has to be original. Nobody can fabricate these kind of details. The time, date, car number, persons, and so on, visiting the CBI director. And on the basis of that, this court then ordered an SIT to be constituted because he was being visited by several people who were being investigated by the CBI at that point of time. But I'm saying that sometimes I get information from people whom I don't know. But I know that this is authentic information because I can make out by looking at it that this has to be authentic. In that case, my lord, initially the court asked me to disclose who gave you the register. So this was a petition by CPIL. We held a meeting of CPIL and we decided that, of course, I didn't even know, but we decided to take a principled stand that whistleblower has given it and we can't disclose the name of the whistleblower. So I'm saying that a political party can easily turn around and say, we don't know who has given it. Somebody left it because this is a bearer bond. Now, my lord, coming back to the submissions, and therefore they say we have now introduced these electoral bonds because, in fact, my lord, this is at the whole.
What was the electoral trust?
Electoral trust is now is a
2013.
kind of
that was 2013.
semi-anonymous instrument. This is what it is. So any company can form or set up what is called an electoral trust, so long as it is recognized by the income tax department. In this electoral trust, any company can donate. So let's say that any company A has set up an electoral trust. Companies B, C, D, E, etc., they all donate to that trust. And that trust then donates to different political parties. So it's a kind of semi-anonymous system. Semi-anonymous meaning, of course, in income tax, they have to disclose who are the companies who have donated to this trust. They are also expected to disclose which are the political parties to which the trust has donated. But which company has donated to which political party is not known. Sometimes they may say, well, we didn't say, but in fact, my lord, what would be happening, I expect, would be every company donating to an electoral trust would say, look, I am giving this trust 50 crores and we want this 50 crores to be donated to A and B political parties. Normally, that's what is likely to have been happening, likely to be happening through these electoral trusts. So this is also a kind of semi-anonymous way, not totally anonymous, because you can come to know which are the companies who have donated to this electoral trust, and you can also come to know which are the political parties that this electoral trust has donated how much money to. So in that sense, there is more information than you have by way of electoral bond. But now, the justification, so the government said that we want to reduce cash. Earlier, people were donating through cash, and therefore, they also said that we have reduced this disclosure requirement from anything above 20,000 rupees to anything above 2,000 rupees. Though, my lord, that amendment was only made in Income Tax Act, not followed through in the Representation of People Act. But let's assume that it would have been made even in the Representation of People Act. That means the law earlier was that you have to disclose any donations above 20,000 rupees. The political party has to disclose to the income tax as well as to the election commission. Anything received above 20,000 rupees, that has been brought down to 2,000. How will that reduce cash? Because earlier the party said that, look, we have received X crores by way of donations, small donations below 20,000. Now they will say, we have received the same X crores by way of small donations below 2,000. That's not going to make any difference, because all that the party has to say is, we put out a sheet, we held a rally, we put out a chadar, and people put money in that. Somebody put 500 rupees, somebody put 200 rupees, somebody put 100 rupees, etc. And we have collected X number of crores from small donations in this manner. So therefore, that is not going to make any difference. If you had said, on the contrary, that every political party will only take money through banking channels and cash receipts are prohibited, they are a corrupt practice, or that the party shall be deregistered if it starts taking money, or the candidate will be disqualified if he takes money by cash, then yes, you could have done something to stop this menace of cash, etc. This has not stopped the menace of cash. Today, my lord, candidates are still spending many times the amount by way of cash, and they are not being caught.